The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Well, hello and welcome to our Curious Amalgam, the official podcast of the Antitrust Section of the American Bar Association. My name is Matthew Reynolds. Today's episode is How Do I Make a Competition Law Complaint in India? A practical discussion about approaching the CCI. One of the best things about the ABA's Antitrust Section is its truly international reach. Antitrust Section events, publications, and programs, and dare I say even this podcast, play a key role in fostering international education and understanding about competition laws and regimes across the globe. As competition lawyers with international clientele, one of the most fundamental questions that we need to be equipped to answer is, what do I do when a client based in a jurisdiction other than my own comes to me with suspicions or evidence of a competition law violation? Of course, I'm sure our professional responsibility colleagues would emphasize that one of the first steps should be connecting with appropriate legal counsel admitted to practice in that jurisdiction. But it doesn't hurt for us to have our own working knowledge of that process as well. And that's what we're going to talk about today with respect to one of the largest economies in the world, India. My co-host for today's discussion is my friend and colleague, Matthew Hall. Hello, Matthew.
Hi, Matt.
Can you introduce us to our guest for today's discussion?
Sure. Our guest today is Abir Roy. Abir is a partner and co-founder of law firm Sarvada Legal, based in New Delhi. He specializes in Indian competition law and dispute resolution, and amongst many other cases, has been involved in numerous complex digital markets cases in India. Hello, Abir, and welcome to the show.
Hi, Matthew. Thank you for having me.
Well, thank you very much for coming on. As Matt said in his introduction, we are going to be discussing today what to do about a competition law concern in India. We are looking at a procedure set out in the Indian Competition Act 2002, whereby an information, i.e. a complaint, can be filed with the Competition Commission of India, or the CCI, about anti-competitive agreements or abuses of a dominant position impacting India. I think the word information is important here because, as I understand it, this means that any third party can use the procedure, not just a party directly aggrieved by the alleged behavior. If a prima facie case is shown, the Director General in the CCI must carry out an investigation and report on it to the CCI. That's a preliminary finding, leading ultimately to a final decision of the CCI. It's a lengthy quasi-judicial process. And of course, listeners will be aware that this sounds similar to provisions in various other jurisdictions. For example, formal complaints can be made to the European Commission in Brussels about infringements of EU competition law rules. So, Abir, before we get into more detail, could you just talk to us give us a high-level overview of the number of complaints being made to the CCI in recent years? What topics and sectors has it been looked at?
Thanks, Matthew. So, how you started, I think it was very, very right when the Indian law uses the word information and not a complaint. So you need not be a person personally directly aggrieved by the conduct. Any third party can file what is known as an information before the CCI. Now, today we are in 2024. The substantive or the enforcement provisions came into being in 2009. So we are actually in our 15th year of enforcement of antitrust laws in India. Personally, I would like to divide this into two phases. First, phase one would be 2009 to 2020 and post 2020. The reason for doing is in the first phase, when the enforcement provisions were notified, a lot of cases were in the cartel related issues, bid rigging in government procurement, and also cement and steel sector and infrastructure sector as far as cartel cases are concerned. There were also certain abuse of dominance cases which were investigated in the first phase in the coal sector, power sector, real estate sector, the automobile sector, and the stock exchange market sector. There were not too many cases before 2020 in the what we now call as the digital slash e-commerce sector. But there has been a gradual shift from 2020 onwards, perhaps something to do with the pandemic and our dependence on the e-commerce activities which are there. So from 2021 onwards, there has been a lot of emphasis, a lot of investigations on digital e-commerce. We have obviously the big tech investigations which are going around in India. We recently had a couple of infringement decisions against Google in India. In fact, there was also a decision against Meta for its data protection practice privacy policy of WhatsApp. The last annual report, which is published by the CCI in 2022-2023, mentions that the information technology sector is a primary area of focus, followed by pharmaceutical and financial sectors. So these are the kind of sectors which have been looked into by the CCI since 2009. Now, on your first part of the question, in terms of pure statistics, if I may say so, the published last three annual reports mentions that there were a total number of around 156 informations were filed before the CCI, out of which investigation orders were passed only in 51 of them. So in more than 100, the CCI did not even find a prima facie case for investigation. And out of those 51, around there were 40 infringement decisions. In this calendar year alone, when I'm talking about January to November, you have had a total number of 42 prima facie orders which have been passed, out of which only six have passed the muster of what we call as the 26-1 order, which is the order directing Director General to investigate. Out of which one was obviously against the big tech. Other five, there's not much detail because it doesn't give the nature or the opposite party which is mentioned there. Typically, what happens is the cartel cases which are being investigated are never put on CCI website. Only the case numbers is given, so I presume those may be cartel cases, but I cannot definitely say for sure. But statistics wise, there's only been six cases which have passed the 26-1 muster, which are being investigated by the CCI. So more than 36 cases were closed at the prima facie stage itself. So that I would say is the high level overview of how the enforcement action has been as far as India is concerned.
Thanks, Abir. That's a great summary. I think we're going to come back to the issue of the standard of proof for a prima facie case and what is needed to get over that initial hurdle to order the DG, the Director General, to start his or her investigation. You mentioned a couple of cases there in passing. In researching for this podcast, I looked at or saw reference to some other recent examples. Could you take us through in a bit more detail some of these to the extent they're in the public domain? In particular, I've seen reference to Swiggy and Zomato, which I understand to be food delivery companies being investigated, and also Walmart stroke Flipkart and Amazon in the online sales area seem to have been looked at by the CCI under this information procedure. It'd be useful to understand a bit more what is known in the public domain about those cases.
So let me put these two examples that you spoke about in a broader category of e-commerce, because those are e-commerce companies. Some may be in a separate market, but broadly it's e-commerce. Now, the e-commerce market in India in general, and specifically for the two examples that you mentioned, are there are two prominent players in the market. So it's essentially a duopoly. Under the Indian law, the way the competition jurisprudence has evolved through the years, the CCI has taken a call that you cannot have two dominant enterprises in India in the same relevant market. So that was the stance of the CCI since beginning, and it continues till date. So what the change happened was the investigations now, which you mentioned, are not under an abuse of dominance section, but under the anti-competitive agreement section. So what is being looked at is that the agreements that these platforms have with certain restaurants in case of Swiggy, Zomato, or certain sellers in case of Amazon and Flipkart, are they giving preference to certain sellers in comparison to the other players in who are operating on their platform? So preferences in terms of search ranking buyers, better deals, better discounting, uh, and ex- and the other kind of issues which are there, which give preferences. These are being looked at in these two particular cases.
Okay, that's good to know, Abir. So we've looked at what the procedure is. We've looked at the history of it going back to 2009, as you say, and what's being looked at the moment by the CCI. You made reference, or we've discussed the issue of the prima facie case. So it'd be interesting to understand, as from your point of view as a practitioner, what is required in putting together a complaint or an information to the CCI, and the level of evidence that the CCI is requiring now, whether it's in particular in cases which are outside the cartel area.
So it's a very interesting question, which is there, which we as practitioners are also facing. I think before I delve deep down into what kind of evidence that we have seen in practice, slightly a legal background which may be relevant for our listeners is that the Supreme Court of India has actually looked into the standard which is required from a prima facie view. What it says is it requires a minimal rational. There need not be a deep dive analysis at the prima facie stage itself. What you need to make out is a very prima facie case or a preliminary case, and in the Supreme Court's own word, it is merely an administrative direction. While we say that there is an administrative direction, lately we have seen a practice by the CCI being a more matured regulator than what it was, say, when in 2009. Even when you file an information, generally they call all the parties for arguments to make out even a prima facie case for investigation. And what the CCI has come to the view, which has been upheld by the appellate tribunal, is that you cannot make bald allegations. There has to be some amount of analysis as to how that conduct causes what we termed as an appreciable adverse effect on competition in market, or what is normally known as the effects doctrine or the theory of harm. In fact, it's very interesting for our listeners to understand that even it's not that all the cases against quote unquote big tech have passed the prima facie stage. There have been some cases against big tech also, which the CCI said that there's no prima facie evidence which is being made out, and hence the matter did not even proceed for investigation. So, having said that, while the legal rationale is still a preliminary understanding, as a practitioner, I think the level of evidence and the analysis which is being required is slightly more nuanced right now, and you actually have to show a theory of harm. Now, when I say theory of harm, you can show it by an economist report. You can show it by various your own sales figures, own turnover figures, which are there. You have to look at market reports, which you need to annex, and how that particular practice that you're alleging, especially like you mentioned, in a non-cartel scenario, causes harm in the market. Now, it's actually at times it becomes a chicken and egg situation, because unless you investigate, how can you definitely say, as an informant who may or may not be aggrieved, as to what is the harm in the market. But certain level of analysis has to be there, wherein you need to show that this is the practice. If it gets rolled out in the market, this will cause this effect. Or if the practice is already in play, what is the harm which has been caused to the competition, not the competitor, the competition or the market. One needs to demonstrate, and thus create a theory of harm at the prima facie stage itself.
So that's useful. So you've explained to us that the basic test would be an appreciable adverse effect on competition at this prima facie stage. And also, it's clear from what you're saying that there needs to be actual evidence provided to the CCI to the extent available to the complainant. In terms of big tech, you mentioned not all passed this test. I've seen reference to a Kaira and Google case where that test was not met. Is that a good example of that?
So a couple of examples I would give. You have the Google Meet, for example, which is akin to Zoom. Uh, the allegation was that Google is tying Google Meet with its platform. The CCI said they are not tying it. You are not forced to use Google Meet. So there is no mandatory imposition of Google Meet. Same thing happened with WhatsApp. WhatsApp has a WhatsApp Pay, which is the UPI, it's a financial instrument in India. The allegation was WhatsApp being a dominant player as far as communications are concerned. They are bundling their WhatsApp Pay with WhatsApp. The CCI said they are not bundling. You can still use WhatsApp and not use WhatsApp Pay. So there's no foreclosure effect in the market. So these are the two classic cases of big tech cases, or big tech players against whom an information was filed, but there was no investigation.
Because they didn't pass the prima facie test.
Yes.
Okay. So looking at the actual procedure, Abir, could you take us through, again, from your point of view as a practitioner, and what happens in practice? The period of time we're talking about in terms of preparing an actual document or complaint for the CCI, maybe some kind of preliminary discussion with the CCI, and then what happens when the CCI is actually formally provided with the information material.
So as far as the preparatory time which is being required to file an information, there's no pre-filing consultation with the CCI as far as enforcement actions are concerned. So what we need to do is more as a homework, where you need to get all the evidences which are there in the market. Reliance on obviously, if there's similar practices which foreign regulators have opined, those are very, very helpful. But you need to demonstrate that those effects are also felt on the Indian market. So those practices have to be there, which have come in India and has an effect on the market. So a lot of time which is gone into discussing with the clients, discussing with the economists, discussing with the experts, in collating and understanding the evidence, and then drafting a formal complaint. So in my experience, you would be taking around 30 to 45 days to draft a proper complaint. Obviously, it depends from multiple factors. It depends on the evidence that we have. Some are relatively simpler in terms of timelines, because the effect may be too evident, as far as, like you said, in cartel cases, for example. In non-cartel cases, if obviously if there's a dominant player which is there, and you have market reports suggesting that they have high market share, and you can show some amount of foreclosure which is there, then the exercise is relatively more simpler, and in terms of drafting. So I would say around 30 to 45 days is required for a proper complaint to be filed. But obviously, these are all, it's dependent on multiple other factors. Once obviously you have filed a complaint with the CCI, you have to give it 2 to 3 months, because like I mentioned in my introductory remarks also, that they do call upon the parties. It becomes actually a hearing to determine whether a prima facie case has been made out. So you will have parties, that is the informant as well as the opposite party, come and give their arguments, followed by written notes. So that takes around 2 3 months, and in another, give it a couple of more months to determine whether a prima facie case has been even made out. So you're looking at a 6 to 7 month process.
So if the decision is that a prima facie case is made out, as I understand it, the DG within CCI is then asked to prepare a report looking at, which is essentially a fact-finding exercise, which he then provides to the full CCI for its ultimately leading to a final decision. What's the time scale for that stage of the procedure?
So the two examples on digital e-commerce, which we mentioned, it took around 3 years. The Zomato Swiggy, for example, I think the prima facie case was made in 2021, and the report came out sometime in 2024. Amazon was slightly a longer case because there were certain administrative challenges which was there, so it took around 4 to 5 years. It actually depends on a multiple factors. There are certain cases which are decided, investigation reports which are decided within 2 to 3 years. There are certain which take more time, because perhaps it also depends on how the DG spends its manpower on the cases which they believe are more in terms of priority, in terms of enforcement. As far as the digital big tech cases are concerned, at an average, it is taking around 2.5 to 3 years for the investigation to be completed. In other cartel cases, it's taking much, much more.
So from the point of, even if you reach the point of having a prima facie case accepted by the CCI, to get to a final decision of the CCI following the DG's investigation report, you're potentially looking at a quite significant period there.
Yes. So you're talking about 3 to 3.5 years, uh, sometimes even more. So you are.
Okay. So
So
I guess
then,
that moves us on to the issue of remedies, and maybe you could refer to interim remedies in your response, Abir, but presumably in most cases what a complainant's filing an information is looking for is some kind of order or remedy from the CCI. How does that work? Can you get interim remedies during the procedure, and what ultimately happens when if the CCI reaches a final decision? Is it making simply a declaration, or is it ordering remedies, or is it maybe imposing a fine? What's the final outcome here?
so legally speaking, yes, you can ask for an interim remedy. There's a particular provision under the Competition Act, Section 33, which says that during the course of the inquiry, the CCI can grant interim reliefs in terms of cease and desist and other remedies if the CCI deems fit. So during the inquiry, the CCI has the power to grant interim remedies, but this power by the CCI is sparingly used. So you can count the limited number of cases where interim remedies has been granted. It, as per the last three annual reports, it has been only granted around 11 to 12 times. So it's very, very sparingly used. So you have to show a higher degree of a case, not a prima facie case or a preliminary case like we mentioned earlier. You have to show a higher threshold of a prima facie case. You have to show balance of convenience and also irreparable harm. And under the Indian laws, generally, not only on the qua the CCA but general administrative decisions of Indian courts, monetary compensation is not a yardstick of irreparable harm, because you can always get the money back. You need to show certain amount of irreparable harm to get an interim relief in your favor. So to that extent, for that standard, while the law provides for that machinery of interim relief, it is sparingly given by the CCI. Now, as far as the final reliefs are concerned, the CCI obviously, if they find the opposite party to be guilty of anti-competitive conduct, they will obviously declare those actions to be abusive or engaging in anti-competitive conduct. But they can also pass remedies or remedial directions, wherein it mostly are behavioral. The law also provides for division of the enterprise, but it has not yet been used. So most of the orders which are being passed by the CCI are in terms of behavioral remedies, in addition to cease and desist.
And would you then see aggrieved parties seeking compensation as a kind of follow-on type claim, as we would refer to it in the EU and UK, before the courts?
So yes, the law does say that once a CCI has found a particular practice to be anti-competitive by a particular player in the market, the aggrieved parties can go to the appellate tribunal to seek compensation. So there have been a couple of cases not yet decided, because that's how the machinery functions. Because practically what happens is the CCI will pass an infringement finding, which in most of the cases, if not 100% of those cases, will be appealed by the party concerned. They will appeal before the appellate tribunal. And practically speaking, the appellate tribunal will first dispose of the appeal. And only if they find that that yes, the practice did infringe competition law, or in other words, uphold the CCI findings, will they hear the compensation application. So the compensation application is heard only after an infringement finding is done by the CCI as well as by appellate tribunal in all practical circumstances. So there have been few cases which have been filed where the matter has been finally settled all the way to the Supreme Court, saying that there was a violation of competition law, and the aggrieved parties have now come before the appellate tribunal seeking for compensation. Not yet a final decision has been passed on compensation, but the law does exist, and we may see more actions in the future, but none as of now, and this is the 15th year of our enforcement practice.
And if I can pose a practical question, in instances where an investigation is ordered, in your experience, what role does the complainant or the complainant's counsel potentially play during the course of that investigation? Is it very hands-off? Thank you very much. We will take it from here. Or can the complainant continue to play a role in helping out with the investigation or providing additional information as that investigation is ongoing?
So it can be very hands-on. So let me again pause for a moment and answer this first legally. One of the reasons why the word used was information and not complaint is basically in administrative laws in India. If you're a complainant, you have to drive the process. So that's why it was made an information, because the CCI/DG does not need your inputs to take forward the investigation. But if you are personally aggrieved, now coming to practical, what happens is, if you are personally aggrieved, like for example, in all these cases which Matthew mentioned, the Zomato Swiggy cases and the Amazon Flipkart cases or the other big tech cases, you had the affected parties give periodic submissions to the DG, sometimes on the request of DG or sometimes on their own accord, saying that this is the data, this is the information, this is how I've been personally affected, this is how the market is getting affected. So the complainant and the complainant's counsel does play a very, very affirmative role during the entire process practically.
So, as in other jurisdictions, the easier you can make it for the CCI case officer in terms of evidence and arguments, the better it is for you, I guess.
That's right, because at the end of the day, you have to drive the process and you have to show that the information that I filed saying that ABC is causing me harm is actually the case.
I think the process that we've talked about today sounds to me, and I suspect will sound to some of our listeners, a lot like a whistleblower process that we have in the US. And I'm curious, is there any confidentiality or anonymity provision, any protection for a third party who wants to file an information but doesn't want their identity to be disclosed to the entity or persons they're complaining about?
So yes, I think it's a very practical question. You have informants or the affected parties who don't want their identity to be revealed. So they can actually file what is known as a confidential and a non-confidential version. And in the non-confidential version, their identity can be redacted. And if it can be shown that my business interest will be affected if my identity is disclosed. Having said that, the commission, if it finds necessary and expedient in their own administrative discretion, can remove that protection. So that power is also there. What also typically happens is, I think, taking forward this question, and it may be very helpful for your listeners, is during the entire DG process, whether it's informants or certain other aggrieved players who come forward and give their own version of the events, they may want to have their identity and what they're giving as confidential because they don't want the other party or the opposite party to know. So they also file a confidential version of the submission and a non-confidential version of the submissions. So when the report is out, the DG has to prepare two versions, a confidential version and a non-confidential version. In the non-confidential version, everything will be blackened out. So a practical issue arose wherein the party, especially the defendants, said that how can I defend where half of the information is redacted? So the commission, first on an ad hoc basis and now as a provision in the law, has created what is known as a confidentiality ring, wherein access is only given to a limited number of players, or sorry, a limited number of representatives of the companies, where they have to sign an undertaking with the CCA and also give it to the other party, saying that we are a part of the ring, we'll get access to every record only for the limited purposes of the case and will not use it for business purposes. So those are kind of inbuilt protections which have been created to manage A, the safeguarding the information and the confidentiality, and B, the right of the parties who want to effectively present their case before the CCA.
Very important practical points indeed. I wanted to ask you finally on the substance, Abir, about a couple of other practical issues. Firstly, I imagine this can get quite expensive, and the extent to which litigation funding might be available or similar generally in India, and particularly for this type of issue, and also what this is not directly relevant, I guess, to the question of filing an information, but what is the status of direct actions in court? So instead of making a complaint stroke information to the CCI, to what extent are parties taking tortious claims, breach of statutory duty type claims directly in court, trying to prove the infringement themselves?
So let me take the second question first. So under a lot of laws in India, especially the regulatory laws, there is always a provision which is inbuilt called the bar on jurisdiction clause. So no civil courts in India can entertain any matter on which the Competition Commission has the power to adjudicate upon. So you cannot take a competition law action to a civil court in India, whether on the commercial side or the High Court, etc. In fact, recently there was a case wherein a lot of app developers did go to a court, which is another high court on the commercial side, wherein they had actually argued that the actions of Google in that matter was in breach of tort, like you mentioned, and other provisions of the law. The Madras High Court actually said that this subject matter belongs to the exclusive domain of the CCI. So you have to go to the CCI, and did not entertain the suit in that particular case. So to that extent, if, for example, if it's a pure competition law issue, then the CC has the exclusive domain. Having said that, there were a couple of decisions which have also said that you can have same bundle of facts which can lead to multiple legal violations. So if you can fashion a particular practice as not a breach of competition law, but breach of some other statute, or breach of pure contract, or say an unfair bargaining position, theoretically you can go to the courts, but I think it has to be tested out in time. And this particular case that I mentioned is now before the Supreme Court. The Madras High Court, the app developers have appealed to the Supreme Court. When the Supreme Court, I guess the decision, whenever it comes out, should give a clarity.
Subject to that last point, Abir, this seems to make the CCI a real gatekeeper on competition law claims in India, and presumably it has only a very limited capacity given the potential number of cases there could be.
So yes, competition cases can only go to the CCI. You cannot go to the courts, unlike some of the other jurisdictions. The Indian law is very clear, and I would say the CCI is not the only body. For example, you have other tribunals like the Electricity Tribunal or the other securities law issues. You have to go to that particular regulator because that's how the regulatory jurisprudence in India has developed. That you have a sector specific or a specialized regulator which has been formed to look into those issues. So yes, your first question is there that the CCI can only look into competition law matters and nothing else. So that's the legal part of it. Practically, I guess I think you have a point wherein because of the manpower, limited manpower which is there, and the kind of issues which economy like India should have, I guess the manpower needs to be strengthened so that they can absorb so many cases. Otherwise, this always becomes a matter of priority, wherein certain sectors are being investigated more and not all the other sectors. So that's a manpower issue which the government of India is looking into. So we are hopeful that in the near future this will be the CCI, both at the investigation level and as well as the adjudicatory level, will be further strengthened.
They probably needed as well to deal with additional merger filings that we heard about in another podcast following the introduction of the deal value threshold. And finally, Abir, in relation to my previous question about litigation funding, is that a realistic possibility for these types of complaints, or not really?
So before we jump into third party funding as well as competition law is concerned, third party funding as a concept in India is quite new. We do not have yet a great clarity as to whether it is allowed or not. Obviously, the Delhi High Court has come up with a judgment in, I think, a couple of years back, paving the way for third party funding. So you have a lot of third party funding which is being done in arbitration cases. As far as competition law cases are concerned, because of the time taken, I guess the funders will come in only after the infringement decision finally has been done, and now the aggrieved party would want to take an action before the appellate tribunal. Because unlike the UK, and correct me if I'm wrong, you can actually approach the courts for both an infringement finding as well as a damages claim. So that's only one proceeding. In India, like the South African model, you will have multiple proceedings before you can actually have a compensation action going your way. So you will need to first win at the CCI, win again at the appellate tribunal, perhaps win again at the Supreme Court before a proper compensation application has been filed, depending on the facts which have been finally decided by all the tribunals and all the courts in the country. So perhaps at that level, the funders will come in. You have, like I said, there only has been a couple of cases, handful of cases, But as and when there are more and more cases on compensation which are filed, we can see more funders which are coming in. As of now, we have not heard of. I personally haven't heard of funders coming in for pure pay competition actions as yet. But time may come soon when there will be more damages actions which are there before the appellate tribunal.
Well, Abir, thank you so much for this interesting discussion. I think we covered a lot of ground in this podcast, and I'm sure our listeners are grateful for this great introduction. We like to wrap up our podcasts with a segment where we learn a little bit more about you as a person. The first thing I wanted to ask is for you to tell us something interesting about yourself that maybe your own professional colleagues don't know about you.
So, I hail from the eastern part of India, which is West Bengal, which is Calcutta. So you have a lot of what we call as Bengalis living in the Delhi region where I practice law. So I stay in this place called Gurgaon, which is adjacent city to Delhi. And in Gurgaon, you have a proper Bengali association. You have a lot of Bengalis who stay there. So there was an association which was formed around 30 or 35 years ago to foster the Bengali culture in Gurgaon. So now I have become the president of that association. So apart from running my own law firm, a lot of my time goes into managing that association purely pro bono, but something which I'm very passionate about. So that is something very few of my colleagues and very dear friends of mine know, but I think the greater audience or the greater Indian competition law bar doesn't know about that.
Well, that's wonderful. Well, if they're listening to our podcast now, they do know. Well, we're going to conclude our discussion today, as we always do, with a segment that we call the Curious Hat.
And now it's time for the Curious Hat.
So, Abir, your randomly selected Curious Hat question for today is there any popular food that you dislike intensely?
I don't like sushi that much.
And what is it about sushi that you don't like? Is there something specific you can share with our listeners?
Oh, there's nothing as such specific. I think when I go to a restaurant and see the menu, I think there will be other things which I'm more interested in having and consuming rather than sushi. So I think dislike is not the right word, but it is definitely not a priority. And when I do have it, it will be a last resort. And that last resort hasn't come yet, as of now.
Fair enough. Well, Abir, thank you so much once again for joining us for this episode, and thanks for your insights and this educational opportunity to learn about filing informations regarding competition law violations in India. And thanks to you all, thanks to my co-host Matthew, and thanks to you all the listeners for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.